Good night, everyone. We are going to start this live tonight. Tonight I want to focus on the Anguilla Constitution, the 2017 draft that was prepared by the Constitutional Reform Committee and led by Justice Don Mitchell QC, and it also includes amendments that were inputted by the government of Anguilla. And so I'll highlight what some of those amendments were, and I'll also discuss some of the FCO proposals that I've been able to get hold of. So just to rewind and back up a little bit, on Monday of last week, myself along with other independent candidates attended a meeting set up by the, the Anguilla negotiating team to meet with the team from the FCO. In order to prepare for that meeting, they forwarded the draft constitution, which I referenced, which is also on gov.ai. And I'm hoping, I know it's a huge document, but I am hoping that persons either read it, had a chance to go through it. If not, the link is on my page. You can follow along if you go to gov.ai. So we were invited to that meeting and was given this document. However, I believe it would have been the day before that meeting, someone posted some of the proposals by the FCO on Facebook, and thankfully I copied and printed those and took them to the meeting, because it was to my dismay that no one else at the meeting had access to this document. And it raised several concerns, because how can you engage in meaningful dialogue regarding the amendments to this constitution if you don't know what some of those proposals were? So that was a major disappointment for me. Thankfully, I had partial information from that document and was able to go through it with my team, which included a legal person with knowledge of the 2017 draft, who had extensively been involved reviewing that draft. And so I had the opportunity to go through that along with the proposals with that person. And so tonight I will highlight just a few of the issues that we found with the constitution and the drafts, areas of concern. I'll let you know what some of those areas were that we addressed with the team from the FCO. I know that the government of Anguilla and the negotiating team, they held a town hall meeting last Wednesday with the FCO team, and persons were very passionate about a particular issue, but unfortunately I think we missed the opportunity to really delve into what some of the other issues are. And this is by no means saying that the issue that the majority of persons took issue with is any lesser than the other issues. But again, I think we missed a huge opportunity to be able to address them in an open forum. Now, part of that may have been a lack of access to the information, and so that's why tonight I'm really going to go through this with you. So we will start with chapter 1, which deals with the protection of the fundamental rights and freedoms again, chapter 1, section 2, the area that most persons, and again, I'm going to go through this very, very briefly, just in case, persons may have missed that exchange on Wednesday. The draft proposal states, whereas every person in Anguilla is entitled to the fundamental rights and freedoms of the individual. That is to say, the right, whatever his race, place of origin, political opinions, color, creed, or sex, but subject to respect for the rights and freedoms of others and for the public interest, to each and all of the following. So we're going to stop there for a second, and we're going to look at one of the proposals from the FCO, where notably the change that they are proposing would be without distinction of any kind, such as sex, race, color, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth, sexual orientation, or other status. So this is the area that caused most concern for the majority of persons on Wednesday, and it's the area that has to deal with sexual orientation. Now, the first nominated member of the House who is chairing the Anguilla negotiations with the FCO has alluded to, or not even alluded, he has stated that the Anguilla negotiating team has been negotiating to have this removed so as to not infringe or to not cause a problem down the line when we start to speak about the right to marry. And so we're going to get to that, but Anguilla being a majority Christian nation, I know the majority of persons in attendance had really strong and passionate beliefs on whether or not that should be included, and I think overwhelmingly so, the majority of persons who spoke that evening felt as if though it should not be included. So that is something that I think both the FCO team and the Anguilla team are very much aware of Anguillian stance on the matter, and so we're not going to go over that anymore tonight because too much time have already been spent on what I think as Anguillians as a majority have agreed on. Additionally, we will move on to section 3, which also gathered some responses that evening, where it says protection of right to life, and in particular we're going to look at section 3, number 3A. It says a person shall not be regarded as having been deprived of his life in contravention of this section if he dies as a result of the use to such extent and in such circumstances as are permitted by law of such force as is reasonably justifiable. A, for the defense of any person from violence or for the defense of property. The FCO proposal recommends that the words "or for the defense of property" be deleted. Now, this is one of the areas that I brought up with the team, and it raised some concerns for the legal person that I had been speaking to, because the claim is that there's case law already providing for the defense of property as a right that is justifiable. However, they also cited cases out of the UK where I remember in particular they cited a case of a farmer who shot a man in defense of his property, and the courts decided it was not enough for him to do so. And so that is another one of the areas that I would hope that the negotiating team can work out with them. Again, it was one of the areas that was brought up that night at the town hall. Another area which speaks to subsection 3, and a lot of these proposals from the FCO is so that the Anguilla Constitution is in line with the European Convention on Human Rights, of which the UK is a party to, and as Anguilla is a dependent territory of the UK, is extended to us as well. And so the question of replacing the words "such force as is reasonably justifiable" with the words "force which is no more than absolutely necessary." Again, that is something that I am hopeful that both the negotiating team and the FCO can come to common ground on. So we move along to this is section 14. We're skipping along to those areas that me and my team highlighted to be, sorry, this is section 15. Sorry. Protection from discrimination on the grounds of race, etc. Again, it deals with discrimination. I will highlight at this point that I commend the government of Anguilla for including in section 15, subsection 3, where it says, in this section, the expression of discriminatory means affording different treatment to different persons, attributable wholly or mainly to their respective descriptions by race, place of origin, political opinions, religion, disability, color, creed, or sex, whereby persons of one such description are subjected to disabilities or restrictions to which persons of another such description are not made subject or are accorded privileges or advantages which are not accorded to persons of another such description. A lot of legal jargon, but I brought this up to highlight the inclusion of disability here, because I find that there aren't much protections in Anguilla currently for persons who are disabled in terms of our building codes. While we don't openly discriminate, I don't think we are as inclusive as we could be or should be. So I am very pleased to see and highlighted the inclusion of disabilities in the protections from discrimination. So just wanted to highlight that. Another subsection from this area that I wanted to highlight was subsection 4D, in which the FCO proposals state, and I quote, it reads, for the provision of services in favor of Anguillians. And the recommendation is that this should be deleted, and I quote them by saying, it seems excessive in allowing discrimination in the provision of services in favor of Anguillians. This is another area that was brought up on Thursday, though very, very briefly. From my recollection in that meeting that we, the independent candidates, had with the FCO team, when I brought this up, I was told they wanted to protect non-nationals, and the analogy that they gave was, let's just say a non-national presented themselves to the hospital for treatment, and a doctor can simply say, well, I don't have to provide services for you because you are not Anguillian. And so by that measure, they want to protect persons from discrimination simply because they are not Anguillian. On the flip side, I would have heard, again, the first nominated member, Mr. Jose Vanterpool, in his argument for the inclusion of this provision would have been, again, the example that he used was if the government of Anguilla wanted to provide scholarships, but they wanted to say that those scholarships were exclusively for Anguillians, Anguillians, then that's what this provision seeks to allow them to be able to do, so that they aren't discriminating, which of course it is, but it's saying that by the inclusion of this, it grants them the right to do so. And so that is another area. I am not here to tell you what position to take on it. It is simply to present to you the issues and the facts at hand, and for you to be able to formulate a position on all of these areas. And again, I encourage you to read as much as is possible the Constitution, seek out clarification from the negotiating team. The government of Anguilla has a responsibility to ensure that the general public is informed of everything that goes into this Constitution, because ultimately this is the document that decides what are your rights and responsibilities as a citizen of this country, even a resident, quite frankly. So that was subsection 4, in which we spoke about the services in favor of Anguillians. If I may revert somewhat, a section 14 is a inclusion, 14A is an inclusion to the 2017 draft by the government of Anguilla, which includes the protection of the right to marry. Now, I can only assume that this section was included to counter the initial rights where we spoke about the inclusion of sexual orientation in the initial rights. Now, they included the protection of the right to marry in 14A, and it says, notwithstanding anything in section 15, which is the section that we just went through, every man and woman of marriageable age, as determined by or under any law, has the right to marry a person of the opposite sex and to found a family. Now, after the whole discussion on Wednesday, I would have spoken to Jose on this matter, trying to get better clarity as to whether or not the protection of right to life, whether the fundamental rights and freedoms of the individual, which would have included sexual orientation, would have trumped this protection of right to marry, which included the right to marry a person of the opposite sex. And so the fear that the government of Anguilla and the negotiating team have is that those fundamental rights will ultimately trump this section of the Constitution where it says the right to marry a person of the opposite sex. And so this is where those negotiations are still ongoing, and I hope that the negotiating team, whether that's the team now or post-election, will be able to find some sort of common ground on this to ensure that the Constitution reflects the will of the people. And so we move along to I will say there is I believe it was section 42, which deals with the responsibilities of the governor. And I was very surprised on Wednesday when Deanne Kentish Rogers, the candidate for District 4, she quoted a recommendation for section 42 that is completely different from section 42 in the draft that I currently have. And so I have not been able to review the section that she quoted and that the FCO team was very much aware of. So I'm not certain if that came about after the negotiations had started, but it's clearly not the section that is currently in the draft that is on the Government of Anguilla's website. And it is very important that as Anguillians we see what powers are granted to the governor of Anguilla. And so I will have to skip over that because clearly what I have here is null and void. I will then skip to the FCO proposals, and one of the proposals that they have is the right to education. And this section was taken from the Virgin Islands Constitution, and it says this section is without prejudice to section 12. Every child of the appropriate age, as provided by law, shall be entitled to receive primary education, which shall, subject to subsection 4, be free. Now, one of the things that I brought up with the team is that currently, primary and secondary education in Anguilla is free. According to our Education Act, every child is entitled to an education until the age of 17, I believe it is, 16 or 17. And therefore, my suggestion was that there be an amendment to this section that says shall be entitled to receive primary and secondary education, which shall, subject to subsection 4, be free. I'll go through the rest of this section really quickly. It says, except with his or her own consent, or in the case of a minor, the consent of his or her parent or legal guardian, no person attending a public educational institution shall be required to receive religious instruction or take part in or attend any religious ceremony or observance. 4. Every person who is the parent or legal guardian of a child shall be entitled to have his or her child of whatever age educated at his or her own expense unless a law otherwise provides in a private school. That is to say, a school other than one established by a public authority, and in such a school to ensure the religious and moral education of his or her child is in accordance with his or her own convictions. Nothing in any law, 5, nothing in any law or done under its authority shall be held to contravene subsection 4 to the extent that it is reasonably justifiable in democratic society and to the extent that the law makes provision requiring private schools as a condition of their being allowed to operate and on terms that are no more onerous than are applicable to schools established by a public authority to satisfy such minimum educational standards, including standards relating to the qualification of teaching staff and other staff, as may be prescribed by or under that or any other law, and B, such minimum standards imposed in the interest of public order, public morality, or public health as be so prescribed. So again, a lot of legal jargon, but suffice to say, it is simply stating every child shall be entitled to free education no child shall be subjected to religious instruction unless with his or her own consent, or if a minor, the consent of their parent or guardian. And every parent or legal guardian is entitled to have their child educated at their own expense at a private school if they so desire. So that's the long and short of the right to education that the FCO has proposed be included in our Constitution, and on that personally I have no objections, again, except to say that it should include secondary as well. We move along to some other areas that I feel needs to be highlighted. Section and this is the area that deals with the House of Assembly, and it speaks to the composition of the legislature and the power to make laws. There shall be a 53(1), there shall be a legislature of Anguilla which shall consist of Her Majesty and a House of Assembly. Simply put, we have a House of Assembly, and every law that is passed by the House of Assembly must be assented to by Her Majesty through the Governor of Anguilla, who is the Queen's representative in Anguilla. Subject to this Constitution, the Assembly may make laws for the peace, order, and good government of Anguilla. The Assembly shall consist of a Speaker elected as provided in Section 69 of this Constitution, not less than 11 elected members and 2 non-voting ex officio members, namely the Attorney General and the Deputy Governor. So at this point, I'll just like to break that down. As we know, with the passage of the 2019 Elections Act, this one right here, after the 2020 election, we will no longer have a first nominated and second nominated member of the House of Assembly. We will only have 2 non-voting ex officio members, the AG and the DG, and 11 elected members, 7 from the districts and 4 from the at-large. I think by now we are all aware that there will be at-large voting because I am here as your candidate for one of those seats. So I see no reason for this to not take place, as we've already included, and it has been included in the amendments to the Constitution that were made via order in council earlier this year. So this is simply just reflecting that. Moving along, for a law made under Section 66 may alter the number of elected members of the Assembly, provided that the number of elected members shall not be less than 11, but no such law shall come into force, A, unless where the law provides for an alteration in the number of electoral districts referred to in Section 66 of this Constitution. A bill providing for the altered number of electoral districts and their boundaries to take account of the altered number of elected members has been passed following a report by an Electoral District Boundaries Commission, and B, until the dissolution of the Assembly next following the enactment of such law. Again, simply, you cannot increase the number of persons in the House unless there is an altered number of electoral districts as decided by a Electoral Boundaries Commission, and after the dissolution of the Assembly following the enactment of such law. So even if law came into effect just as the Constitution was amended in 2019 and the Elections Act was passed in 2019, there will still be no more than the 7 elected members in the House of Assembly until this current assembly has been dissolved. So it doesn't take effect until after the next general election. Moving along, we'll skip along to qualifications for elected membership. Subject to the provisions of the next following section, a person shall be qualified to be elected as a member of the assembly if and shall not be qualified to be so elected unless he is an Anguillian of 21 years or upwards who is registered as a voter in an electoral district in Anguilla and either A, was born in Anguilla and is domiciled there at the date of his nomination for election, or B, has resided in Anguilla for a period of not less than 3 years immediately before the date of his nomination for election and is domiciled there at the date and is the son or daughter of parents, at least one of whom was born in Anguilla, or is the grandchild of grandparents, at least one of whom was born in Anguilla. Now, this section is a amendment made by the government of Anguilla. It was not in the initial 2017 report. And what this seeks to do is to allow for persons who may not have been born in Anguilla but is the child of at least one parent or the grandchild of at least one grandparent who was born in Anguilla. Prior to this, the grandchildren of Anguillians were not eligible if they themselves were not born in Anguilla. A grandchild could not seek elected office. But this seeks to include grandchildren in the qualified persons who can seek elected membership. And again, I note with that, it specifically states for a person who was not born in Anguilla and is seeking qualification based on their Anguillian citizenship, belongership, due to being the child of a born Anguillian or a born Anguillian grandparent, then that person must have resided in Anguilla for 3 years immediately before the date of his or her nomination. And so, if you'd like to seek elected representation in the House of Assembly and you are Anguillian through your parents or grandparents, in order to do so, you must first be resident, and you don't live on Anguilla, then you must first be resident for 3 years immediately before the nomination date. Disqualifications for elected membership. 55. And there is a note here, 67, it says, this section was amended from the present provision of the 1982 Constitution in accordance with the recommendations at paragraphs 86 to 90 of the 2006 report, which again is on the Government of Anguilla's website, gov.ai, to remove the disqualifications for ministers of religion and persons with dual citizenship. Now, this again is the 2017 draft, and I believe that those amendments were already made in the 2019 Constitution, the amendments to the 2019 amendments to the 1982 Constitution, which was done via order in council. And so it says, no person shall be qualified to be elected as a member of the assembly who holds or is acting in any office of emolument in the service of the crown, B is an undischarged bankrupt, having been adjudged or otherwise declared bankrupt under any law enforced in any country. C is a person certified to be insane or otherwise adjudged to be of unsound mind under any law enforced in Anguilla. D has been convicted by any court of law in any country of an offense of dishonesty or immorality. E is a party to or a partner in a firm or a director or manager of a company which is a party to any contract with the government and has not, by that date, disclosed in a notice to the Integrity Commission the nature of such contract and his interest or the interest of such firm or company in it, or is disqualified for membership in the Assembly by any law enforced in Anguilla relating to offenses connected with elections. So simply it speaks to who would be disqualified, and if you have any issues with what is there, again, I encourage persons to let their views be known to the government of Anguilla and the negotiating team, so that when they're negotiating views that reflect those of the general public. Vacation of seat on sentence, and we're going to just keep going through. Okay. I highlighted this one simply because of a case in the BVI recently, where after elections earlier this year, there was an elected person who wanted to resign his seat, and I think in their constitution, he was required to write his letter of resignation to the Speaker of the House. But because there was no speaker at the time, he wrote his letter to the governor. And so the question came up as to whether or not his resignation letter was valid. Ultimately, it went to the courts. And, he then changed his mind and said he did not want to resign. And so the speaker at the time refused to swear him into the House of Assembly, decided it needed to go to the court to decide whether or not the resignation letter was valid. Ultimately, the court decided it was not valid, and so the member had been sworn into the House of Assembly. And so I wanted to see if our Constitution made any allowances for something like that. And it speaks to the vacation of seat on sentence, where if a elected member is convicted by a court of law in any country of an offense of dishonesty or immorality, he shall forthwith cease to perform his functions as a member of the House of Assembly, and his seat in the Assembly shall become vacant at the expiration of a period of 30 days thereafter. There's a provision that from time to time, the Speaker may extend the period for 30 days to enable the member to pursue any appeal in respect of his conviction or sentence. So, however, that extensions of time exceeding in the aggregate 330 days shall not be given without approval of the Assembly. So, I think that is saying 11 months. You can get extensions up until 11 months. It also, there is an area where it speaks to that specific problem that I spoke about from the Virgin Islands, where I know that in order to resign, the member must write to the governor, and so we would avoid that situation. So we move along to the power to provide for a referendum. Now, during the town hall meeting with the FCO team, a lot of mention was made of referendums, whether we should have a referendum to adopt this constitution. There were mentions of whether or not we should have a referendum to move towards independence if we did not necessarily care for some of the powers of the governor in terms of our relationship with the United Kingdom, what were our options outside of that. And so there was a lot of mention of the power to provide about referendum. So I want to speak to what the Constitution says about the power to provide for a referendum. 61, so section 61, subsection 1 says, a law enacted by the Assembly may make provision to hold a referendum amongst persons registered as voters in accordance with section 65 of this Constitution on a matter or matters of national importance when so resolved by the majority of elected members of the Assembly. But the question of whether Anguilla should seek any amendment to this Constitution that may result in its independence shall be deemed to be a matter of national importance and shall require a 2/3 majority of those voting. So there you have it, that as would be included in our Constitution if we get to the point of speaking about seeking our independence, a referendum must be held, and such referendum will require a 2/3 majority, not just a simple majority of 51, but a 2/3 majority of those persons voting, and only persons who are registered to vote can vote in such referendum. Subject to this Constitution, a referendum under this section shall be binding on the government and the Assembly if assented to by more than 50% of persons voted. Again, this is with the exception of a referendum on the matter of independence. Before we look at section 62, subsection 2A, subsection 2, it says, before a referendum under this section may be held, there shall be presented to the Cabinet a petition signed by not less than 25% of persons registered as voters in accordance with section 65 of this Constitution. The Cabinet shall settle the wording of a referendum question or questions within a reasonable time period as prescribed by law, and C, the Cabinet shall make a determination on the date the referendum shall be held in a manner prescribed by law. So this here is basically saying, before you can even have the referendum, 25% of persons registered as voters must sign a petition presented to Cabinet. So you have a petition first, signed by 25% of persons, and then a referendum which must be voted on, and in order for that to hold, it must be at least 51% of voters, or in the case of independent, 2/3 of the registered voting population. Penalty for qualification, and I will say that this area, it says penalty for sitting or voting in assembly when unqualified. Any person who sits or votes in the assembly after it has been held by the High Court that he is not entitled to do so shall be liable to a penalty established from time to time by law. Any such penalty shall be recoverable by civil action in the High Court at the suit of the Attorney General. Qualification of voters. Subsection 1 is still under review in relation to residence requirements. I remember just a few months ago, there was a consultation held by the government of Anguilla regarding this very same area. And it's unfortunate that many people did not show up to those consultations and let their views be known, especially since it was also broadcast by Lloyd. I remember clearly because I wasn't able to make it, but I participated via that medium. And so I encourage persons to utilize whatever mediums are available to let their views be known. It is important that we do so. So section 65(1) in this draft says, subject to the next following subsection, a person shall be qualified to be registered as a voter in an electoral district and in a single electoral district if he is of 18 years of age and upwards, and A, is an Anguillian born in Anguilla and is domiciled there at the qualifying date, or B1, is an Anguillian who has resided in Anguilla for a period of not less than 12 months immediately before the qualifying date and is domiciled there at that date, and is the lawful spouse, widow of widower, or the son or daughter, or the spouse of such son or daughter of a person who was born in Anguilla, or 2, is an Anguillian who is domiciled in Anguilla and has resided there for a period of at least 5 years immediately before the qualifying date, and C, is at the qualifying date resident in the electoral district in which he claims to be registered. Now, this is an area that has gathered much debate because the question is whether or not persons should be entitled to vote in an election in Anguilla even if they have taken up residency in another country. So someone ceased to reside in Anguilla, they are Anguillian by every definition of the word. However, they no longer reside in Anguilla. I have not resided in Anguilla for a period of 12 months or 3 years, depending on, 5 years, depending on how they have gained their Anguillian belongership status. The question surrounding this was what happens to students. And so I brought this up with my legal person, and the definition that they gave was, or the explanation, that they gave was that a student would still be ordinarily resident in Anguilla if not for the fact that they were seeking higher education. And so the question was whether or not we should include a provision excluding students from these qualifications, meeting these qualifications. The overwhelming response that I've seen and gotten from persons is that the persons feel if Anguillians, and I will say this seems to be an issue of a generational divide, because I think at least from the responses that I've seen from persons, is that persons from a younger generation feel like it is not right for someone who is not resident in Anguilla to be able to vote in Anguilla, regardless of whether or not they own property, whether they visit several times a year several times in between elections, or not in a year, several times in between elections. As long as they're not resident in Anguilla, there are persons who feel that those persons should be excluded from the voters list. And so that is why there is a huge outcry for the voters list to be cleaned up. Because as we all know, the voters list is heavily inundated by persons who, according to these requirements, should not be able to vote. However, if your name is on the voters list and your name isn't queried, questioned, or contested, then you are entitled to vote. And so that raises a huge concern. I know, and we will come up on it, where I know there's a section that speaks to the voters list being completely wiped and redone every 10 years, so as to eliminate the idea that once you are registered for life, but rather once you are registered and you remain resident in Anguilla, then you are entitled to re-register every remuneration year. And so we'll get to that section shortly. So moving on, it says every person who is qualified to be registered as a voter in any electoral district shall be entitled to be so registered, provided that a person shall not be registered as a voter in more than one electoral district apart from a single electoral district. 3. In this section, qualifying date means such date as may be appointed by or under any law as the date with reference to which the qualifications of persons for registration as voters for the purpose of the election of members of the House of Assembly are to be ascertained. 4. In this section and section 65A, single electoral district means a single electoral district provided for by legislation and enacted under section 66(2). And that, okay. No person shall be qualified to be, and so we spoke about the qualifications, now we speak about disqualifications of registered voters. No person shall be qualified to be registered as a voter who A. is under sentence of death imposed by him by a court of law in any country, or is under a sentence of imprisonment by whatever name called exceeding 12 months imposed on him by such a court, or substituted by competent authority for some other sentence imposed on him by such a court, provided that the acts constituting the offense for which such sentence was imposed would, if committed in Anguilla, have constituted an offense under the law of Anguilla. B. Is a person certified to be insane or otherwise adjudged to be of unsound mind under any law enforced in Anguilla, or C. Is disqualified for registration as a voter by any law enforced in Anguilla relating to offenses connected with elections. For the purposes of paragraph A of the preceding subsection, A. 2 or more terms of imprisonment that are required to be served consecutively shall be regarded as a single term of imprisonment for the aggregated period of those terms, and B. No account shall be taken of a sentence of imprisonment imposed and as an alternative to or in default of the payment of a fine. Within 6 months after the coming into effect of this Constitution, and as such times thereafter as the Governor may by proclamation direct, a new list of voters qualified under this Constitution shall be prepared by enumeration process to be provided for in a law governing the registration of voters, and thereupon the existing list of voters shall become void. Thereafter, the list of voters shall constantly be updated by a process of continuous registration of qualified new voters. And so this brings us back to that note that I was just speaking about. And it is a note that says it is intended that no person should be entitled to remain permanently on the list of voters as presently obtains, no matter how long he has ceased to reside in Anguilla. The intention is that the New Elections Act should provide that periodically, example, every 10-year census, there shall be a new enumeration process. And this provision is designed to authorize the preparation of a new list of voters who are qualified under the new test of ordinary residents in Anguilla. And so there's a whole section included as the laws as to the elections, elected members, and then it goes on to speak to institutions protecting good governance. And there's a note here that says the number and types of commissions and commissioners have not yet been agreed. And so I'll go through them very quickly and very briefly. It says we should have an electoral boundary commission, and the electoral boundary commission shall be appointed from time to time at such time as the governor, after consultation with the premier and leader of the opposition, may determine, but a commission shall be appointed not later than 10 years after the last commission submitted its report under section 87 of this. And so an electoral boundary, district boundary commission would be one that would look at the boundaries in any district, determine whether that district should be divided, whether it's too large, to ensure that each district is proportional in its representation. So we'll go through just the different types of commissions recommended. A public service commission, a teaching service commission, a police service commission, a national security commission, a financial services commission, which already exists, a judicial and legal services commission, an integrity commission. And I'm going to just stop here at the integrity commission for a little bit. There's been a lot of talk about an integrity commission for Anguilla. And it says the primary, and I'm going to skip to where it says the primary responsibility of the integrity commission shall be to promote integrity, honesty, and good faith in public life in Anguilla. The integrity commission shall have and exercise the functions conferred on it by sections 37, 55, 98, and 126 of this Constitution, formulate and publish, after public consultation in Anguilla, a code of conduct for persons in public life, keep the code under review and amend or replace it as it considers necessary or desirable, and in accordance with any law, investigate any alleged failures to abide by the code by persons subject to it, either in response to a complaint or on its own initiative. C. Contribute to the public education about integrity in public life. And D. Have and exercise such other functions for the purpose of fulfilling its primary responsibility under subsection 2, including the imposition of penalties as may be conferred on it by law. Just skipping a bit, the Integrity Commission shall make an annual report to the Assembly about its activities and shall send a copy of each report to the governor, who shall ensure that any such report is published and made widely available. And just a note, the Integrity Commission inclusion in this, it says, in accordance generally with paragraph 135 of the 2006 report, say the wording is taken from sections 102 and 103 of the Turks and Caicos Constitution. Note that subsection 5 of the TCI precedent is omitted as being a duplication of section 103. So that's just a note. To me, this is one of the most important commissions that we can have as Anguillians when we speak about wanting accountability and transparency, when we speak about holding persons in position of authority responsible. An integrity commission is integral to those tenets of accountability and transparency. So that is one area that I strongly recommend is included and is not omitted from this constitution. And so it goes on to speak about registration of interest, where shall be a public document published on a government website, otherwise made generally available to public scrutiny and maintained by the Integrity Commission. I think we can understand why there would need to be a registration of interest, just to ensure that there's no commingling of any public-private life issues. Moving on to the amendment that deals with Anguillian status. And this was another area of concern for one of the candidates, and I think overall of how this issue being raised before, in terms of Anguillian status and who is conferred Anguillian status. And so just quickly I will go through and says there shall be an Anguillian status commission. For the purposes of this constitution, a person shall be regarded as an Anguillian if that person, A, is a person born or adopted in or outside Anguilla and who has at least one parent or grandparent who was born or adopted in Anguilla, where such parent or grandparent is regarded as being an Anguillian by virtue of this constitution, or is regarded as belonging to Anguilla by virtue of any previous constitution. B, is regarded as belonging to Anguilla by virtue of this constitution as in force before the commencement of the Anguilla Constitution Amendment Order 2019, or of any previous constitution. C, it is a British Overseas Territories citizen having been born or adopted in Anguilla and having become such a citizen by virtue of registration or naturalization while resident in Anguilla. D is a British Overseas Territories citizen domiciled in Anguilla and whose father or mother by virtue of registration or naturalization while resident in Anguilla became a British Dependent Territory citizen at the commencement of the British Nationality Act 1981, or would have done so but for his or her death, or so became such a citizen after the commencement of that act. E has been granted Anguillian status by the Commission on the basis that that person, 1, is a great-grandchild of a person born in Anguilla and who is regarded as being an Anguillian by virtue of this constitution, or is regarded as belonging to Anguilla by virtue of any previous constitution where the great-grandchild has resided in Anguilla for a continuous period of at least 5 years, or has resided in Anguilla for a continuous period of at least 15 years, or is born in Anguilla and is a child under the age of 18 years of a person referred to in subparagraph 2. is a person outside Anguilla and is the child under the age of 18 of a person referred to in subparagraph 2, where the child has resided in Anguilla for a continuous period of at least 3 years, or is born in Anguilla and does not qualify under any of the foregoing provisions of this subsection, but has resided in Anguilla for a continuous period of at least 10 years, or is married to an Anguillian and has been so married for at least 5 years. And so I'm going to back up just a little bit at this point, just before we wrap up. So the subsection that says is born in Anguilla and does not qualify under any of the foregoing provisions of this subsection, but has resided in Anguilla for a continuous period of at least 10 years. Now, this section in particular came up when we spoke about the issue of persons who were born in Anguilla. So you are born here, but you are ultimately deemed stateless because you are not granted Anguillian status by virtue of your birth, and the native country of your parents refuse to acknowledge your nationality, or your parents refuses to confer your parents' nationality to you because you were not born in that country. And so there are lots of cases of children in Anguilla who are ultimately stateless. They are left without any nationality until, according to this, they gain the age of 10, having lived in Anguilla for 10 continuous years. And so that is an area of concern about having children who are ultimately stateless, and what is our responsibility to those children. And again, there should be, moving along with the different commissions, a commission of inquiry, and a human rights commissioner, a complaints commissioner, police complaints commissioner, public procurement commissioner, and freedom of information commissioner. Supervisor of elections, and they start to say it's under review to determine whether an electoral commission is preferable. And a commission of public assets. And then we have chapter 10, which speaks to public finance, which simply says still under review, and there is nothing more to that. And on that note, I will end there. I hope that this live has been informative, that I have provided information on some of the areas that are in the draft constitution, that it has piqued your interest to go to gov.ai. A direct link to the draft constitution is included on my page, Gleneva Age 2020. Click on that link, review the Constitution as it is as much as you can. Walk in groups, whether you just sit with your friends, whether it's in your church, whether it's at home with your family. These are matters of national importance that should not be politicized, which is why I have, for the most part, tried to refrain from giving my personal opinion on the matter, because I think it's a matter that deserves to have persons formulate their own opinion without the influence of a politician. Politicians, look out for politicians' interests in the most part. And so, as Anguillians, it is important that we look out for the interests of our people, its current position and its future, because a constitution isn't just for today. A constitution lasts decades. The last constitution and the first constitution that Anguilla had was in 1982. We are now approaching 2020. I leave you with that. Thank you for joining me, and I hope to see you on my next live. And feel free to share this with anyone who can benefit from the knowledge. What I will attempt to do is to have the FCO proposals compiled into a document and have a link to that document posted on my Facebook page as well, so that you can also review those proposals. Thank you and have a good night.